good evening and welcome to the 5 St Andrews Hill webinar on defending accountants in regulatory proceedings, and also the FCA's approved personal regime and the fit and proper person test. My name is Guy Micklewright. I'm a tenant at 5 St Andrews Hill and I specialise in professional discipline and regulatory work. I've been acting for accountancy regulators since 2010 and defending accountants in proceedings before their regulators forms an increasingly large part of my practice. I'm joined by my colleagues Matthew Corrie and Sarah Wood. Matthew is ranked in Chambers and Partners and as a leading junior in the Legal 500. Like me, he is also a specialist professional regulatory practitioner with significant experience in defending accountants. It is said of him that he is a junior who demonstrates excellent judgment in complex and challenging cases, and that he is able to deal with tough cases forcefully and properly. Additionally, my colleague Sarah Wood is in the Legal 500, is the Legal 500 Financial Crime Junior of the Year 2023, and she is ranked also in both directories as a leading junior in POCA and asset forfeiture. It's said of her that she is unflappable with clients and on her feet, and a calm and assured presence in the midst of contentious litigation, and that she is fantastic and very clever. She has a really soft approach and is like a silent assassin. She is highly regarded for her knowledge of financial regulation. We will deal with any questions that you may have right at the very end, so I'd encourage you to make them as we go along, but we won't seek to address them then. Please, if you would, use the question and answer function rather than the chat function to ask them, and we will collate them as we go along with a view to answering them later. Next slide, please. I'm going to begin by talking to you about disciplinary tribunal hearings, what happens there, and offer some suggestions as to how you may wish to approach the hearings, and also to deal with the processes adopted by regulators on their internal appeals. My colleague Matthew is then going to come along and deal much more broadly with the overall process relating to cases before professional regulators, and how to approach at those earlier stages, in particular in the lifetime of a case. And then towards the end, my colleague Sarah will come on and deal with the fit and proper person test. So the four topics I'm going to cover are there on that slide, which is procedure, charges, evidence, and sanction. Dealing firstly with procedure. Next slide, please. All regulators have a case management process contained within their rules, and this is something which will be dealt with in a bit more detail by Matthew in due course. However, those processes require, by the disciplinary tribunal stage, and I just pause to say by disciplinary tribunal, I'm using that as a sort of catch-all term. Different regulators use different names for the disciplinary tribunal. But those processes, by the time you reach that substantive hearing, require disclosure of not merely the regulator's case, but also the defence case in response to be made within a certain time frame. And for any application for any evidence not served within that time frame to be made for permission to allow it to be relied upon. As with most disciplinary tribunals across various sectors in professional discipline, provided there's not substantial unfairness to the regulator, and certainly if the late disclosure is due to some failure by the regulator themselves or an unforeseen circumstance, then it's generally been my experience that tribunals tend to be sympathetic to such applications. It may be, for example, that you've been instructed late, as is not uncommon at all in defending accountancy cases, and are therefore unable to complete the work that needs to be done in time for disclosure. it may be that there are less impressive reasons why you're not in a position to be able to serve in time. Regardless of the reason, if you're going to be late, my suggestion is that you take proactive steps to keep the regulator informed of what you're anticipating disclosing and by when. You're more likely then to get a sympathetic response by the time you end up at a hearing, or indeed if you make an application at a case management hearing, than you might otherwise be. Documents which are unlikely to cause much objection at all, I should think, are going to be evidence of remediation, of insight, of reflection, and indeed of means. And that's because, for the most part, they don't hugely impact on the role that the advocate for the regulator is going to be taking during the course of the substantive hearing. I've referred to case management hearings, generally where applications need to be made, for example, for an adjournment, or indeed in relation to permission to rely on documents late. Those are matters which can often be decided without an oral hearing. It's certainly beneficial to do so if you can. It keeps your costs down, it keeps the regulator's costs down, and also it ensures that the uses of the regulator resources are proportionate. That's relevant because I think without exception, all of the regulators retain a power for themselves to get costs from your client in the event that you lose all or part of the case. And it's something which you will need to have your eye on right from the very beginning. It should be remembered, just as a general point throughout, that unlike regulators like the GMC, none of the accountancy regulators that we're talking about this evening are creatures of statute. They are all unincorporated associations or incorporated associations with a royal charter. The relationship between the members and the regulator is therefore at its heart a contractual one. However, because of the nature of the regulatory exercise is one with a public law flavour to it, most of the procedures that they follow and their regulations and rules are imbibed with a public law flavour as a result. And so accordingly, public law principles of natural justice are engaged. But remember, because of the greater freedom that these bodies have to make their own rules, and the fact that they don't, for the most part, for example, have to go to the Privy Council to get rules approved, that means that they generally have greater divergence between each regulator, and similarly greater procedural flexibility than a lot of the statutory regulators have adopted. Because there's no power to do so, evidence is not given on oath. All tribunals will generally have, as I say, the power to manage their own procedure, albeit they tend to follow the same structure as both between themselves and also as is generally incorporated into the regulations at a hearing. By default, I think I'm right in saying all of the regulators now provide in their rules that hearings will take place in public. And so if any part of it is to take place in private, an application will need to be made. And similarly so in respect of the publication of the decision. Generally, these hearings will adopt a two-stage process: fact-finding and sanction. And within the scope of that first, what I've called fact-finding stage, it will be consideration of whether or not the basis upon which the alleged misconduct, I'll call it misconduct by way of a general term, is alleged, is made out. I've mentioned costs. Tribunals, as a matter of course, make costs awards in favour of the regulators for the costs of investigation and prosecution, along with the cost of setting up the hearing and paying for the attendance of tribunal members. You would expect, and if you haven't seen one, ask for a schedule of costs to be served in advance of the hearing, although in practice often it's not served very long before. Generally, it tends to be calculated on either an hourly rate or a fixed rate, really depending on how the prosecuting advocate is charging. for the legal expenses and simply then for the costs as incurred for the attendance of members and the use of the facilities. Most regulators' rules contain the power to award the costs against the regulator, although bear in mind that if you're seeking costs against the regulator, the principles in Baxendale Walker will apply, but some, such as the AAT, notably, specifically omit that provision. So the AAT, in principle, could run a case shambolically from start to finish, and it would not be possible to recover costs against them. Next slide, please. The allegations or charges are not drafted in a format which will be familiar to those who have purely practiced in healthcare regulation. They are not narrative in the same way. I've referred to them in this slide as being drafted in an indictment style. That's not entirely fair. That's the approach that is taken, for example, by the Bar Standards Board. What is done is to draft a fairly crisp narrative description of the conduct that gives rise to the allegation, usually with a date range or a specific date, and then to below that plead which part of the bylaws and the codes of conduct or ethics the conduct in question is said to be in breach of, and therefore on what basis it is said to amount to conduct that can be considered by the tribunal. Often there will be multiple bases in regulators' bylaws for misconduct, and they can, on the face of it, appear to be somewhat contorted. For example, and I won't read it all out because it's very, very long, the ICAEW's disciplinary bylaws state that for a member to be liable to disciplinary action, which is the overarching term they use, A, if they have committed misconduct, semicolon, by committing any act or omitted to do any act, whether in the course of carrying out professional work or otherwise, likely to bring discredit upon themselves, ICAEW, or the profession of accountancy, or so as to fall significantly short of the standards reasonably expected of a member, which is a very, very wordy way of alleging misconduct, the misconduct that we're perhaps more familiar with, those of us who also practice in the healthcare sphere, within the healthcare regulators legislation. And then there's a not dissimilarly wordy definition of professional misconduct, professional incompetence. In addition, there's reference to being liable to disciplinary action for committing a breach of the bylaws or of any regulations or various other documents which they produce. And that is not uncommon in a number of these regulators' bylaws or related regulations. And that can be problematic because it can mean that you can fall within the ambit of having committed misconduct or being liable to disciplinary action or whatever the terminology may be, on the face of it, simply by having breached even de minimis part of the code of conduct or code of ethics or whatever it may be. It's worth, if you look as though you may be falling into a situation of that nature, analysing Walker and the BSB, which I've referred to in the bottom of this slide, where the old Bar Code of Conduct used to provide that certain conduct would effectively immediately render you liable if committed to amounting to professional misconduct, and that the circumstances therefore only became relevant to the issue of sanction. In this case, the visitors to the Inns of Court accepted the argument on behalf of the appellant that the notion of seriousness should be incorporated into the test for professional misconduct in order to avoid very minor breaches of a code of conduct leading to it being characterized as professional misconduct. And it seems to me that that is a principle that can, by analogy, apply in certain situations before some of the accountancy regulators. Next slide, please. All of the regulators have slightly different formulations for the test for the admissibility of evidence, but essentially it always comes down to the same thing, which is whether it's firstly relevant and secondly fair. And that's either dealt with via an exemption to evidence being admissible in civil proceedings is admissible, or a provision which simply says that the rules of admissibility of evidence in courts do not apply, but evidence that is admitted must be fairly admitted. So the terms relevant and fair will pretty much apply in all circumstances. In practice, most of the evidence that regulators rely upon in these proceedings will be documentary evidence rather than witness evidence. Often you will see a report in the case bundle, which will contain charges and also the regulator's analysis of the evidence, rather than that document purely being kept for the investigation stage. And I think it's not unfair to say, for it to be not unusual for regulators to be a little bit lackadaisical about their approach to the production of documentary evidence. And often they don't consider whether or not it really is appropriate for a witness to produce it, or to fill in some of the gaps that may exist between those documents. It's appropriate, therefore, I'd suggest, to consider right from the very outset carefully whether or not the evidence is hearsay, inadmissible hearsay, and the point at which you might want to challenge the admissibility of that evidence. Asking yourself whether or not the material is complete, whether or not it's properly produced, and whether or not the regulator has simply decided not to follow up fair and obvious lines of inquiry. Often regulators operate to tight budgets and with limited resources, certainly some of the minor ones anyway, and may be reluctant as a result of such pressures to do so. At the hearing itself, all of the witnesses' evidence will be taken in chief as read. And it's worthwhile noting, if you haven't undertaken one of these hearings before, that, and certainly again, if you come from a healthcare regulatory background, these hearings can be surprisingly short. Matters that might take a healthcare regulator 2 weeks to deal with, I've seen dealt with in a fully contested case in 2 days. Some of those people who sit as chairs on a regular basis at these panels, and one tends to become quite used to those who have been approved to sit on these panels, it can take a very robust approach to the case management of hearings, and your advocacy and case preparation therefore needs to take account of that possibility. It may be that you want to consider making use of written advocacy much more than you might otherwise do. Submitting a skeleton argument, for example, in advance, in order to ensure that your client's getting a proper opportunity to ensure that their case is advanced as fully as it can be. It's perhaps worthwhile liaising with your opponent or with the regulator over the timings of each part of the hearing, particularly in respect of how long you expect your client to be in evidence. That may be a good way of avoiding yourself being railroaded by an overly enthusiastic tribunal into not being given the opportunity you'd like to have to be able to let your client give their evidence. Stage 2 evidence, I suggest, is generally best dealt with when your client gives evidence, rather than hoping that there'll be a second opportunity, because there may well not be. Matthew, I think, will be saying that he is of the same view as I am, which is that evidence of remediation and insight is somewhat infrequently used in these proceedings, and we can't discern a good reason for that. It seems to us that it's something which has great applicability when considering what sanction is appropriate, and a paradigm example where such evidence can be very helpful would be anti-money laundering allegations, particularly where they relate to procedural and policy failings. Evidence of updated policies, further training, audit materials, reflections, or even the engagement of a consultant to assist in the process is the sort of thing that could be very valuable. Next slide, please. I'm conscious of time, so I'm going to move on fairly swiftly through these next two slides. In terms of sanctions, the usual principles that we're all familiar with apply, as are set out in the first bullet point there. Sanctions guidance is published by all of the regulators. Helpfully, they generally contain a number of matrices which set out starting points for various types of conduct, along with aggravating and mitigating features. It should be noted that tribunals are able to impose multiple sanctions, and it's common to impose financial orders as an adjunct to other orders. Be aware, though, that the available sanctions can differ between the category of membership, and in particular note that there are certain sanctions that would be applied if your client is a member in practice, which cannot be applied if your client is not deemed to be a member in practice. Costs is something I've already referred to. Some regulators will permit an appeal against a costs award, others won't, however. So take your client's instructions on means in good time. They can be taken into account and must indeed be taken into account when determining any financial penalty. Do, however, consider pushing back on regulators' applications for costs. Some offer a costs discount for early admissions, ICAW is an example, but most don't. Regulators often don't properly justify the necessity of the costs, the reasonableness or proportionality of those costs, or consider whether or not they are appropriate, bearing in mind the extent or otherwise of their success in the proceedings. It's only to your client's benefit to push back against those and to seek to get the regulator to justify them and to perhaps do so in correspondence in advance of getting to the final day of the hearing. Next slide, please. Finally, appeals, very, very briefly. The appeal that you have, there will always be an internal appeal available to you. If you lose that, then your only other line of challenge is by way of judicial review. The available grounds of appeal are slightly different between all of the regulators. However, they're broadly the same in the sense that there's usually an opportunity to challenge on the basis that the conclusions on facts are wrong or perverse. Secondly, on procedural irregularity. Thirdly, on a disproportionate sanction. And fourthly, on the basis of new evidence. If you are seeking to adduce new evidence, you should have regard to the approach in Adiogba, which points towards the well-known test in Ladd and Marshall, but also incorporates recognition of the public interest as it applies in professional disciplinary cases. Finally, recognise that some, such as the ACCA and the ICAW, require permission to be granted for appeal, but other regulators such as the AAT and SIPFA do not have a permission requirement. So accordingly, in summary, recognise the differences that lie between the individual regulators and ensure you have close regard to them before deciding upon your case strategy. Thank you very much. I'm now going to hand over to Matthew.
Thank you, Guy, for your interesting talk and for your introduction. To those of you who don't know me, my name is Matthew Corrie, and as Guy said, I'm a practitioner who specialises in professional discipline, including defending accountants. It's great to see so many of you logged on. Welcome. I'm going to be talking to you about defending accountants at their regulatory bodies. What I'm going to cover really is an overview of the procedure and then some practical tips about how to approach certain aspects of the process. New slide, please. As you will all know, there is a plethora of bodies which regulate accountants and accounting technicians. You can see on the slide a list of most, if not all, of these. Each of these have their own separate bylaws and regulations which set out their regulatory and disciplinary processes. It is beyond the scope of this talk to go into each of these, but it's right to say that although there are differences, and Guy is right to say that you should check for these differences when you are acting for clients facing proceedings before these regulators, there are broad similarities in their disciplinary processes. Next slide, please. You can see from the next slide that in relation to their disciplinary processes, they have these similarities: bylaws which set out grounds for liability for disciplinary action. They have regulations covering their procedure. They have a process whereby they receive and investigate complaints. They notify the accountants under investigation. An opportunity is provided to respond to allegations. Each of the regulators has a process of consideration of whether there is a case to answer. They generally have a process whereby matters can be disposed of by way of consent. They have a process for the service of evidence and case management. Guy has touched on that. And they have disciplinary hearings, which Guy has also touched on, which are hearings of a type which will be familiar to anyone who practices in professional discipline, where evidence can be called and contested and submissions will be made. As Guy has also alluded to, each of the regulators has their own sanctions guidance and a mechanism of appeal. Next slide, please. It's also worth bearing in mind that as well as a disciplinary function, some of the regulators have a wider function. For example, the ACCA, the ICAEW and ICAS are recognised supervisory bodies, and they have rules which govern how auditors are regulated, which includes approval of firms and individuals as registered audits in relation to audits other than public entities, setting procedures for maintaining their competence, monitoring the conduct of audit work, and dealing with possible breaches and discipline in relation to those breaches. I mention this because it is important to bear this in mind. This regulatory function is a function which is often forgotten by some of us who practice in this area, but it has a significant potential to impact upon an accountant's ability to earn a living. If the main part of their practice relates to auditing, if they no longer meet one of the eligibility requirements, that can have an enormous effect on their ability to continue working. I also mention it because the topic of Sarah's talk touches on the fit and proper test in another context, but members of the ACCA have to be considered fit and proper to have a practicing certificate. There are additional requirements in relation to those who audit in relation to fit and proper, and that applies also in respect of the other bodies that supervise audit function, the RSBs. Like I say, these cases can have a devastating effect on an accountant's ability to earn a living, and it's an area in which I'm increasingly receiving inquiries to advise and act. And the process and procedure is different to the regulatory function. They have broad powers to withdraw audit registration. They have a process of monitoring in place. They will generally have a process of review or appeal of any decision in relation to an application for audit registration or a decision to review and remove audit registration. I touch on that and now move on to some practical tips in relation to how to approach disciplinary proceedings predominantly, but also the regulatory proceedings. Next slide, please, Jamie. One thing that's really important to consider is the duty to cooperate. I've set out on this slide and the subsequent slides the specific instances in relation to some of the regulators where it sets out what the duty to cooperate is. Next slide, please. And next slide, please. I set these out by way of example, but all of the accountancy regulators have a duty to cooperate with them during their assessments, their investigations, and their disciplinary proceedings. This is really important, in my view, for a number of reasons. The first of these, and perhaps the principal of these, is that non-cooperation or partial cooperation can and often does lead to additional charges being brought. The next point is this: cooperating with an investigation, with an assessment, with disciplinary proceedings can be argued as a mitigating factor if you reach the sanction stage. And in fact, in the ICAEW sanctions guidance, it is explicitly set out that full cooperation is a mitigating factor. Of course, we all have cases where requests are made by the regulator for information or material, and one wonders where the line between cooperating and not cooperating lies, and it can sometimes be a fine line. But in my view, it's very important to consider carefully the duty of cooperation and make sure, as far as possible, that your client does cooperate and cannot be criticised for this. Next slide, please. And next slide, please. The next sort of strategic consideration is the communication that you or your client has with the regulator. Those of you who work in these proceedings will know that there are a number of key stages where there will be communication with the regulator. So at the early stages, perhaps during a monitoring visit, such as for money laundering, and follow up on any action points which arise from such a monitoring visit, there will be queries raised of the accountant by the regulator. Secondly, during the investigation stage, it will not be uncommon. In fact, it is routine for requests to be made for responses to particular questions and for information or documentation from an accountant. Thirdly, if it reaches this stage, if an investigation is completed, there'll be an opportunity to make representations to the body that considers whether there's a case to answer. And fourthly, there are, of course, procedural rules in relation to the service of evidence if the matter has been referred for a disciplinary hearing. It's really important to bear in mind that any communication with the regulator can and genuinely will be relied upon by the regulator at a later stage. And although those of us who are lawyers who represent people will be aware of this, many accountants do not realise this. And it is not uncommon, in my experience, for responses at an early stage to be ill thought out and contrary to their best interests. And really, this is perhaps a strong argument for seeking early legal advice, because the approach taken from the outset is really important strategically and in terms of setting the tone, considering how much to say, what to say, but also when considering if you're likely to get to a hearing, that any evidence served in support of a case is going to be consistent with what is said at an early stage of the dialogue. Next slide, please. The next slide really deals with a consideration of case strategy. This may sound obvious, but it's a point that is worth bearing in mind. Early analysis of the issues in the case will put you in the best position to address the issues that arise. Consideration of the likely and desired outcome and how to achieve this. So, is there a case to answer at all? Each case will be different, of course. In some cases, it may be possible to challenge jurisdiction, whether there's a case to answer. Sometimes it will be clear that there is a prospect of being able to dispose of a case by consent. And in other cases, it will be obvious that the matter is going to go to a disciplinary hearing, and you need to prepare it on that basis. Are there any tasks that can be undertaken at an early stage once you've identified your strategy to put yourself in the best position? And you can see in the final bullet point, I used the example of carrying out CPD, producing a reflection, and obtaining witness evidence that you may rely upon in support. Next slide, please. I've already mentioned consent orders in passing, and each of the accountancy bodies has a process by which they can dispose of a referral by way of a consent order. Each of the regulators has a slightly different process. I have stuck on the slides the process followed by the ACCA and the ICAEW. Perhaps you could do the next slide, please, Jamie. Although each has a slightly different process, essentially there needs to be a case to answer, there need to be at least some admissions, there needs to be an acceptance of breach of particular standards, and a sanction and costs have to be agreed. When matters are dealt with by consent, there is a restriction on the powers available, and so generally speaking, the most severe or onerous sanction that can be agreed is a severe reprimand. And so cases where you cannot exclude the possibility of an accountant being excluded from membership are unlikely to be suitable to be dealt with by consent. Given the time demands of regulatory proceedings, given the unpredictability of proceedings, and the costs that accountants incur, both in terms of their own legal fees and the regulator's costs, a consent order is often an attractive option in an appropriate case. However, it is important to bear in mind that they are formal orders, there isn't a right of appeal, and importantly, in terms of reputation, just as with an order of the disciplinary committee, they will be subject to publicity in that they will be published on the regulator's website. If a consent order is an outcome that your client wishes to achieve, in my experience, it is useful to open the dialogue at an early stage, make it explicit to the regulator, because although, for example, at the ICAEW, only the conduct committee can offer a consent order, if there is a recommendation from the investigation team, that is likely to carry some weight. Next slide, please. Guy's already spoken to you about case management. I'm going to come to it from a slightly different angle. Again, this might seem obvious, but it is of particular importance in regulatory proceedings at accountancy bodies. Now, I can't speak for everyone's experience of dealing with the accountancy bodies, so what I say is only anecdotal. But often the regulators take what seems like a very long time to complete investigations, can be slow to reply to correspondence, and don't list cases for a long time. However, when the cases do come to life, they really come to life, and there are strict procedural rules which set deadlines for the provision of responses, service of evidence, and so on. I've set out some of these in the slide. So on this slide, you can see reference to the ACCA Complaints and Disciplinary Regulation 10.4, which requires evidence to be served no less than 21 days before a hearing. And you can see the consequences or potential consequences of not complying with that at Regulation 10.4c. The ICAEW rules are even more onerous, as you can see, because evidence is required to be served within 21 days of service of their evidence. Well, 21 days is not very long when you think about the complexity of some of these cases. And often, if you think it's likely that there's going to be a referral to the disciplinary committee and you're anticipating receipt of service of evidence, you'd be well advised to get preparing your case early, because you don't want to be facing an uphill struggle of having to apply to have your evidence adduced, applying the tests set out in those regulations, not least because there's a risk of not being able to rely upon that evidence, although that's pretty unlikely and rarely happens, but because you're likely to have a case management hearing, and it increases the costs. You don't want to start on the back foot. And so if you think you're not going to meet a deadline, and Guy has touched on this, you might have a good reason, you might not have a good reason. But in my experience, the regulators are pretty reasonable, provided you open the dialogue as early as possible. So get in touch and ask for an extension. The earlier on in the process, the more likely they are to agree to it. Next slide, please. This slide really deals with these three issues of how to minimize the impact of any allegations should they be proven. And I'll deal firstly with testimonials. Regulators and disciplinary committees are presented with a very narrow version of a member, which necessarily focuses on the allegation, what they've said to have done wrong on a particular occasion. The provision of testimonial witnesses addresses this, and it allows one to present a fuller and better picture of your client. This sort of evidence is of particular value, you may feel, if the allegations relate to matters of personal conduct, such as dishonesty, lack of integrity, and so on. But in my view, they are still of considerable value, even in cases where you have got allegations of a more technical nature, because they provide the whole picture of the accountant, and they can be very persuasive in mitigation. What about remediation? Well, Guy touched on this, and many of you here, I can see, are people who I know practice in healthcare regulation. Stage 2 material is prepared as a matter of course in healthcare proceedings, much less so, in my experience, in accountancy regulation. And this, in my view, is an area where you can really add value as a legal advisor, because even in a case where you are, or your client is not making admissions, if you can present evidence that shows that they have understood the issues involved, they have carried out relevant learning, and they have provided reflection, that's going to put your client in the best possible position. And I consider that there's a strong argument for always, as a matter of course, trying to prepare that sort of evidence for your client. So there are my thoughts on strategic tips on how to face these proceedings. Thank you for listening, and Sarah will give her talk next.
Thanks, Matthew. I'm going to move on to deal with another area of regulation for accountants that arises in a very discrete and narrow set of circumstances, but is obviously nonetheless important. And it relates to regulation by the FCA as part of its approved persons regime. Since 2019, as most of you will know, the approved persons regime has only applied to individuals, what are known as appointed representatives. And that's because the senior managers and certification regime, or the SM and CR for short, largely replaced the approved persons regime and now applies in all cases where the firm is solely regulated by the FCA. But where a firm, and for our purposes, of course, let's assume that that firm is a firm of accountants, carries on regulated activities, which is obviously, again, usually the provision of investment advice, as an agent of a firm that is directly authorised by the FCA, then they are to be regarded as an appointed representative and are subject to the scope of the approved persons regime. Just by way of example, to make that perhaps a little clearer, a number of barristers use Place Campbell to undertake their tax returns and file their accounts. But Place Campbell also offer investment advice as an agent for Close Brothers. And it's within that capacity that they would be regarded as an appointed representative. Given the potential for confusion, it is perhaps not unsurprising that the FCA and the Treasury are working towards extending certain aspects of the SM and CR regime to appointed representatives. Next slide, please, Jamie. Can we have the next slide, please, Jamie? Oh, forgive me, we had moved on. Sorry, it perhaps goes along. Just go back to the. But thank you, Jamie. That's my fault entirely. It perhaps goes without saying that the purpose of the approved persons regime is to protect consumers and the UK financial system by ensuring the quality of individuals carrying on certain activities within the financial services industry. As I've set out on the correct slide, the details of the regime are set out within Part 5 of FSMA 2000 and also Chapter 10A of the Supervision Manual of the FCA Handbook, with further guidance being included within other parts of the handbook that I have provided links to within this presentation, which I know will be distributed after this evening. And so those links will be available for you to click on to obtain the relevant information. But in short, the approved persons regime seeks to achieve its aim through the adoption of the fit and proper person test. As Matthew has touched upon, that's clearly a test that is well known to those of us who undertake regulatory work. But we'll come on to look at what it means within the FCA context in a moment. But in terms of what an approved person is, Section 59 of FSMA defines it as a person that the FCA has given its approval to under that same section, so under Section 59, for the performance of a controlled function. That in turn obviously leads on to consideration of what does the FCA regard as a controlled function. So if we can have the next slide, please, Jamie. There are, in effect, two control functions. The first is called the significant influence functions. That is defined within the relevant rule of the Supervision Manual of the FCA Handbook as being in relation to the carrying on of a regulated activity by a firm, which means a function that is likely to enable the person responsible for its performance to exercise a significant influence on the conduct of the firm's affairs so far as relating to the activity. That's effectively a very wordy way of saying that it is those individuals who are performing the governing functions of a firm. So, for example, the company's directors, any NEDs, and in particular, obviously, the CEO. And that's set out within those paragraphs that I've set out on the screen that you can see in front of you. It probably won't come as any surprise to any of you to hear that those performing those significant influence functions are subject to particularly close regulatory scrutiny, both before their appointment and indeed on an ongoing basis. Moving then to the second control function, if we can have the next slide, please, Jamie. That is the customer dealing function. And in effect, it essentially relates to giving advice on dealing and arranging deals in and managing investments. For the avoidance of doubt, it doesn't apply to deposit taking, lending, general insurance business, or credit-related activities. Moving on to the next slide, please. As you might expect, the FCA will only grant an application for approval if it is satisfied that the candidate is a fit and proper person to perform the function to which the application relates. And it's clearly the interrelationship between the function and the test which is relevant for the FCA's purposes. Now, when considering whether a candidate is fit and proper, the FCA will consider three matters in particular, namely a person's honesty, integrity, and reputation. Secondly, their competence and capability. And thirdly, their financial soundness. The sort of matters to which the FCA will have regard to are set out within Chapter FIT Fit 2.1 of the handbook that I provided the link to on the screen. But just to highlight perhaps at this stage, some of those matters. So, for example, when considering somebody's honesty, integrity, and reputation, when you make the application, the FCA will have regard to whether the person has been convicted of any criminal offence, which includes spent convictions, with particular consideration being given to those offences involving dishonesty, fraud, or financial crime. They'll consider, for example, whether the person has been the subject of any adverse finding or settlement in civil proceedings, again, as you might expect, particularly in connection with fraud, and whether the person has been the subject of any previous investigation or disciplinary proceedings. Within the relevant chapter of the handbook that I provided the link to, there is in fact a list of 13 matters that the FCA will have regard to. But obviously it goes without saying again that the scope of the matters to which the FCA may have regard is not confined to those 13. They will consider everything in the round. So far as the second matter is concerned, which is a person's competence and capability, the FCA will consider, amongst other matters, whether or not the person satisfies the relevant FCA training and competence requires, again, coming back in relation to the particular function that they are going to be performing, and whether they can demonstrate experience in this area. It is perhaps worth noting that the guidance does highlight that a person may have been previously convicted of or dismissed or suspended from employment for drug or alcohol abuses. But this will only be considered by the FCA if they consider that it impacts a person's ability to perform the relevant function. So you can see the theme here in relation to the importance of the functions that the person will be performing. And then finally, in relation to financial soundness, of the third matter the FCA will consider, it's right to highlight that this doesn't involve any scrutiny or assessment of an individual's financial status. Instead, it relates to a consideration of such matters as whether a person has been the subject of a judgment debt or had a bankruptcy petition served on them. Next slide, please, Jamie. I've just set out briefly within this slide a little bit about what is involved when making the application to become an approved person, not least to highlight that it is the firm which makes the application as opposed to the individual. Now, as part and parcel of that, in order for the firm to be able to satisfy itself that it is putting forward an appropriate candidate, as part of the initial assessment, of a person's fitness and propriety. The recruiting firm must obtain a regulatory reference from the person's current employer and any previous employer within the last 6 years. And over and above that, they must also undertake their own due diligence, including interviews, assessments, and background checks. Again, as you might expect, those who are undertaking the significant influence functions can be expected to be interviewed by the FCA before approval is granted. Next slide, please, Jamie. But assuming for these purposes that the application to become an approved person is successful, then what that effectively means that the individual, and again, for our purposes, let's assume that is an accountant, that individual becomes regulated by the FCA and are therefore personally accountable to the FCA. Now, in order to ensure that the required fitness and propriety is met on an ongoing basis, the individual must continue to satisfy the standards of conduct appropriate to the role and, again, the function that they perform. And in particular, what they must comply with is the FCA's statements of principle and the codes of practice for approved persons, known as the APER, which have been issued under section 464, subsection 1, subsection A of FISMA. I've set out the 7 statements of principle that apply on the next slide, but the purpose of the codes of practice that I provided a link to at the bottom of the slide that you can see in front of you, it is to help determine whether or not the conduct of the approved person complies with any particular statement of principle. And they set out in detail, they're very lengthy, conduct which in the FCA's opinion does or does not comply with the relevant statements of principle. And notably, it also sets out certain factors which in the opinion of the FCA are to be taken into account in determining whether or not an approved person's conduct complies with the relevant statement of principle. And so perhaps, again, goes without saying that if a client approaches you and is concerned that they may have breached one of the statements of principle, then the codes are a good place to start in terms of assessing whether it's likely that any breach will be established. That said, and as you might expect, the codes themselves do stress that they are not binding on the FCA, nor indeed on any court or disciplinary tribunal. They are merely guidance, albeit fairly significant guidance. Next slide, please, Jamie. These are the relevant 7 statements of principle that must be abided by. I'm not going to read them all out. That would be both tedious in the extreme, particularly after 6 p.m. And in any event, none of them are matters that you will find surprising in relation to a document of this nature in terms of what statements and what conduct would be expected of an approved person. It is perhaps just worth highlighting that numbers 1 to 4 apply to all individuals, whereas 5 to 7 only apply to those performing what I've underlined as being accountable higher management functions, i.e. those who are undertaking the significant influence functions. Next slide, please, Jamie. Now, in terms of any enforcement action that may be undertaken by the FCA, where it considers that there has been misconduct by an approved person, and just pausing there, misconduct is defined, as you might expect, as a breach of the statements of principle by an approved person, then the FCA have a wide range of powers available to them. The most powerful weapon in its armoury, perhaps, is a prohibition order under section 56, subsection 1 of FISMA, in circumstances where the FCA consider that the individual is no longer a fit and proper person. This is what it says on the tin and prohibits an individual from acting as an approved person. It's worth noting that it is then a criminal offence if someone then acts in breach of that particular order. Before it makes a prohibition order, the FCA must serve a warning notice on the individual, setting out the proposed terms of the prohibition order. And if it then decides to make the order, it must provide a decision notice, again, setting out in clear terms the details of that prohibition order. An individual who is served with a decision notice may appeal it to the tribunal, which in this case is the Regulatory Decisions Committee, the RDC. Secondly, the FCA may simply withdraw the approved person status. I've just noted that, in fact, I've put the wrong statutory provision within the slide. Section 59 is the section which provides for the granting of the approved person status. It is, in fact, section 63, which provides the power to the FCA to be able to withdraw that approval. Thirdly, if the FCA consider that a person has performed a controlled function whilst not being an approved person, so slightly different in terms of the scope of this one, then it may fine them, and that is provided for by section 63A of FISMA. And then fourthly, the FCA has the power to pursue its own disciplinary proceedings, again before the RDC. The links at the bottom of the slide will direct you to the relevant parts of the FCA handbook, where it sets out the relevant guidance that the FCA should consider when deciding which sanction or route to adopt. But in terms of the sorts of sanction available to the FCA, if it decides to go down the disciplinary route, these are set out on the next slide, please, Jamie. In effect, they may impose an unlimited financial penalty. They may suspend any approval of a particular function up to a period of 2 years. They may impose any condition in relation to the approval of a particular function, again, up to a period of 2 years. They may limit the period for any such approval to have effect within, and they may issue a public statement of the person's misconduct. It goes without saying, and as Guy touched upon, these sanctions are not alternatives to each other, and the FCA, just like other bodies, will combine one or more sanctions, again, against the background referred to in the previous slide in terms of what is considered to be appropriate in the circumstances of any particular case. And by the same token, in terms of the sort of factors to have in mind if you are representing accountants who are before the RDC, then a lot of what Matthew and Guy have said is extremely relevant, with the same sorts of considerations coming into play. But for now, and for these purposes, I hope that provides you with an overview, at least, of the approved persons regime, and how it can be relevant to the regulation of accountants alongside the main bodies that perhaps we're all a bit more familiar with. I am conscious of the time, but I think we may have some time for any questions and answers that may have occurred during the course of the webinar. But I'm going to hand back to Guy, if I may, in relation to dealing with those questions.
Sarah, thank you very much indeed. As it happens, we've yet to have any questions come through. So I think what I'll do is I'll just pause for 30 seconds or so to see whether or not there are any that have occurred to anyone. And particularly in relation, Sarah, to your talk, it may be that nobody's yet formulated a question. But in the meantime, whilst I'm waiting to see whether or not there are any questions that are going to be produced, please do get in contact with us. Anyone who would like a copy of the slides, we'd be very happy to provide those to you. The hyperlinks which are contained within Sarah's slides will be made available within them as well, which will allow you to click on those hyperlinks and go straight to the document she was referring to. This talk will also be in due course on the 5 St Andrews Hill account on YouTube. So anyone who, for whatever reason, wishes to watch it again or wishes to invite colleagues to watch this, then that'll be available online. And in addition, the links which were in Sarah's talk will be available there as well. Well, in that 30 seconds or so that it required for me to say that, there have been no questions. So thank you very much, all of you who've attended, and I wish you a very good evening.